क्या आप भी कानूनी जजमेंट्स को समझने में घंटों लगाते हैं? ये काम अब आसान हो सकता है। पेश है लेक्स जीपीटी, एक ऐसा एआई टूल जो आपको किसी भी कानूनी जजमेंट को सेकंड्स में डिकोड करके समझने में मदद करेगा। चाहे कोई भी कानून हो, कोई भी जजमेंट हो, लेक्स जीपीटी आपको देगा सटीक और तेज विश्लेषण। और खास बात, आपको मिलेगा फ्री स्टैंडर्डाइज्ड प्रॉम्प्ट जो आपके एनालिसिस को और भी बेहतर बनाएगा। अब समय बचाइए, काम कीजिए स्मार्ट और बढ़ाइए अपनी सफलता की संभावना। लेक्स जीपीटी किसी भी कानूनी जजमेंट को समझें तुरंत और आसानी से। अभी खरीदें और आजमाइए।
टैक्स लॉ से परेशान हो? अब चिंता की कोई बात नहीं। लीगल लेंस है ना। टैक्स लॉ अपडेट्स समझने में घंटों लगा देते हो? लीगल लेंस टैक्स एडिशन सब्सक्रिप्शन लो, सबसे आसान और जबरदस्त तरीका अपडेटेड रहने का। हर महीने नए टैक्स केस लॉ अपडेट्स सीधे आपकी स्क्रीन पर। मुश्किल भाषा को कहो बाय बाय। हम कठिन शब्दों को आसान भाषा में समझाते हैं। इंटरेक्टिव चार्ट्स, विजुअल्स और वीडियो एक्सप्लेनर्स के साथ सब कुछ बिल्कुल क्लियर। रियल लाइफ केस स्टडीज से सीखो और टैक्स एक्सपर्ट्स से प्रैक्टिकल गाइडेंस पाओ। चाहे आप सीए हो, सीएस हो, वकील हो या टैक्स कंसल्टेंट, बस एक क्लिक में अपना काम आसान करो। लीगल लेंस टैक्स एडिशन सब्सक्रिप्शन आज ही लो और हर अपडेट से आगे रहो। लिंक डिस्क्रिप्शन में है। स्पेशल लॉन्च ऑफर लिमिटेड टाइम के लिए। अभी एनरोल करो। स्मार्ट टैक्स अपडेट्स और आप भी स्मार्ट।
दोस्तों नमस्कार, मैं हूं मनोज लांबा। आज के जजमेंट एनालिसिस के सेशन में, जैसे कि हमने कल प्रॉमिस किया था, आज हम धारा 263 सेक्शन 263 जो कि कमिश्नर, चीफ कमिश्नर और पीसीआईटी की रिविजनरी पावर्स की बात करता है, जिसमें किसी ऑलरेडी असेस्ड इनकम को रिवाइज किया जा सकता है, ऐसी जजमेंट्स की बात करेंगे। दोस्तों, ये एक बहुत महत्वपूर्ण सेक्शन है, जिस सेक्शन का अधिकतर प्रयोग पीसीआईटी या चीफ कमिश्नर ऑफ इनकम टैक्स करता है जब उसे लगता है कि कोई असेसमेंट ऑर्डर ऐसा है जो प्रेजुडिशियल टू द इंटरेस्ट ऑफ रेवेन्यू है, तो ये ऑर्डर पास वो कर सकता है। लेकिन क्या ये ठीक है? सुप्रीम कोर्ट ने आज से 25 साल पहले मालाबार इंडस्ट्रीज के जजमेंट में ये कह दिया था कि ये प्रेजुडिशियल एंड एरोनियस आर द ट्विन कंडीशंस which both condition is to be satisfied before revising any order. First, the order must be erroneous, and second, that erroneousness must be prejudicial to the interest of revenue. Until or unless both these conditions are satisfied, the Honorable Supreme Court, the apex court of the India, the apex court of the land, has already declared in 2000, 25 years back, that it cannot be revised. Friends, today I am going to discuss with you two very important judgments. One in the favor of the department where revision can be done, and another against the department where revisionary power cannot be exercised. Why these decisions has been given by different tribunals of different jurisdiction, we will also discuss on that. So let's start the discussion without wasting so much of time. If you have any query, if you have any doubt with regard to any judicial pronouncement we are discussing, please don't forget to mention in the chat box. And friends, further tell me on what case law you want a specific video. I will try to bring the video on the same case law. So friends, let's start this discussion. I am sharing my screen with you. Please with me. Please tell in the chat box whether my PPT is visible to you. Everyone is requested to please write in the chat box whether PPT is visible to you or not. Yes, please, whether PPT is visible or not. If nobody is answering, I will presume that PPT is visible. Let's start the discussion, friends. Friends, आज मैं आपके साथ इनकम टैक्स अपीलेट ट्रिब्यूनल नागपुर की एक जजमेंट डिस्कस करने वाला हूं जो कि डिपार्टमेंट के फेवर में है, जहां पर डिपार्टमेंट ने अपहोल्ड किया रिवीजन को अंडर सेक्शन 265 और ये डिसीजन आया सिटी लैंड एसोसिएट्स अमरावती के केस में। क्या थी ये जजमेंट, सारी चीजें हम डिस्कस करेंगे। इस केस में जो पार्टीज इन्वॉल्व थी वो थी सिटी लैंड एसोसिएट इज द अपेलेंट एंड प्रिंसिपल कमिश्नर ऑफ इनकम टैक्स इज द रिस्पोंडेंट। The hearing is before Income Tax Appellate Tribunal, Nagpur bench, and the key issue in this is whether assessment order under section 143, subsection 3, which is a scrutiny assessment, was erroneous. Please note that and prejudicial. Both these words have to be taken. Erroneous as well as prejudicial. Note is to be read alone. The word is and here, not or. So whether the assessment order under section 143 subsection 3 was erroneous and prejudicial to the revenue interest, justifying revision under section 263. What is the background of case? The initial assessment was done under scrutiny assessment, which is completed under section 143 subsection 3 of Income Tax Act 1961, and on the basis of that judgment, the Honorable Principal Commissioner of Income Tax evoked section 263 by exercising his power to revise the assessment. But the assessee has aggrieved with this decision and has applied to the Income Tax Appellate Tribunal for revision of such order. So what are the key contentions of the appellant? Appellant argument was the assessment was completed after scrutiny. The appellant contended that already in-depth scrutiny has already been done under section 143 subsection 3. Please note, my dear friend, whenever an assessment has been done under section 143 subsection 3 of Income Tax Act 1961, the department has done already thorough verification of documents and done thorough investigation, asked detailed questionnaires to that. Only after that assessment was completed. Though in that case, the appellant argued before the tribunal that because my assessment has already been completed under scrutiny, that was no question of revision because already everything has been examined by the AO in detail in that manner in under section 143 subsection 3 of Income Tax Act. But behind that, he argued that behind that additional income of rupees 2.2 crore. Please note that additional income of 2.2 crore has already been accounted for. Consistency with earlier years should be maintained, and no fresh evidence was found justifying their interference. And what the department has argued? The department argued in the manner that AO failed to examine. Department counsel has said assessing officer failed to examine crucial impounded document. Very important, my dear friends. The what department is saying that my AO, my assessing officer, has failed to examine the impounded document which is impounded during the course of search or survey. During the search, a diary is found, and on dairy page number A32 recorded rupee 5.76 crore in cash receipts ignored. But the department has argued that during the course of search a dairy was found, and at the page number A32 of that dairy it is written that some amount of 5.76 crore, and that cash receipt was ignored by our AO, by our learned AO, while making the assessment. AO didn't apply mind to the seized material. Explanation to section 263 justifies revision. फ्रेंड्स, अब मैं आप पे ये बात करना चाहता हूं, अगर मेरे यहां सर्च हो चुकी थी, वहां से जो डायरी, जो पेपर मिले थे वो इंपाउंड हो चुके थे, और उस डायरी के पन्ना नंबर 32 पर 5,76,00,000 की कोई फिगर लिखी थी, और एओ के पास वो सीज मटेरियल होने के बाद भी अगर उस पर उसने दिमाग नहीं लगाया, तो ये गलती किसकी है, एसएससी की या एओ की? ये मैं आपसे चैट बॉक्स में पूछता हूं, ये गलती किसकी है, एसएससी की या एओ की? प्लीज राइट इन द चैट बॉक्स। मेरे पास सीज्ड मटेरियल था, इंपाउंडेड मटेरियल था, पेज नंबर A32 पे लिखा हुआ था 5,36,00,000 रुपए की राशि, जिसे असेसमेंट करते हुए अगर एओ ने अपने दिमाग का इस्तेमाल नहीं किया तो इस बात का दोषी कौन है, एसएससी या एओ? क्या अगर एओ भी ठीक ढंग से काम नहीं करता तो उसके लिए भी मेरे को पेनलाइज किया जाएगा? ऐसा अधिकार सेक्शन 263 देता है? क्या ऐसा मंशा है सेक्शन 263 की? तो जो मैंने ये जजमेंट उठाया आपसे डिस्कस करने के लिए, इस वजह से उठाया, क्या ये एसएससी के टैक्स पेयर चार्टर में लिखे गए अधिकारों का उल्लंघन नहीं है, वायलेशन नहीं है, अनकॉन्स्टिट्यूशनल नहीं है? अगर डिपार्टमेंटल ऑफिसर सही से काम नहीं कर रहा है, सीज मटेरियल उसके पास होते हुए भी, तो उसके लिए दोषी क्या है? लेकिन हमारे इनकम टैक्स अपीलेट महोदया तो कुछ और ही डिसाइड कर रहे हैं। हमारे इनकम टैक्स अपीलेट ट्रिब्यूनल नागपुर ने क्या डिसीजन दिया? नागपुर वाले हमारे इनकम टैक्स अपीलेट ट्रिब्यूनल ने धारा 263 में जो रिवीजन हुई थी उसे अपहेल्ड कर दिया और एसएससी की अपील को डिसमिसल कर दिया। उन्होंने कहा एओ फेल रहा है इस चीज को वेरीफाई और एग्जामिन करने के लिए। किस चीज को वेरीफाई और एग्जामिन करने के लिए? इंपाउंडेड डॉक्यूमेंट्स को। अगर इंपाउंडेड डॉक्यूमेंट्स की वेरीफाई और एग्जामिनेशन में वो फेल रहा है और उसके बाद उसने असेसमेंट कर ली है, तो उसका हर्जाना हमारा निर्दोष एसएससी क्यों भरे? मेरा क्वेश्चन ये है, इस चैलेंज को करना चाहिए। पर्टिकुलरली डायरी नंबर A32 made the assessment order erroneous and prejudicial to the revenue, and the tribunal has said, the honorable ITAT has said, explanation 2 to section 263. Explanation 2 to section 263 applies as AO passed an order without making necessary inquiries. Because the AO has not made necessary inquiry, for that our SSC has to be here. This is very, very relevant question which has to be discussed, which has to be interpreted accordingly. And now what legal principle this judgment has established? Because ITAT is the final fact-finding authority in the income tax law. Only the question of law can be referred to the High Court or Supreme Court as the case may be. But as far as the question of facts are concerned, the question of any particular point is concerned, the ITAT, the honorable ITAT is the final fact-finding authority, and that ITAT of Nagpur has said that AO must conduct, AO को करनी चाहिए थी इन डेप्थ वेरिफिकेशन सारे सीज्ड इंपाउंडेड डॉक्यूमेंट की बिफोर कंप्लीटिंग द असेसमेंट, जिसे वो करने में असमर्थ रहा है। दूसरी चीज, प्रिंसिपल चीफ कमिश्नर ऑफ इनकम टैक्स को ऐसे दशा में अधिकार दिया गया है, कानूनी रूप से अधिकार दिया गया है कि अगर कोई चीज हमारे एओ से अनवेरिफाइड रह जाती है तो ऐसे में प्रिंसिपल चीफ कमिश्नर ऑफ इनकम टैक्स महोदया अपनी पावर्स का एक्सरसाइज करते हुए जो सेक्शन 263 में दी हुई है उस केस की रिवीजन करेंगे. फेलियर टू एग्जामिन सिग्निफिकेंट रिसीट्स in impounded document can lead to revision under section 263. And what are the notable judicial observation by the ITAT? Failure to examine impounded material, particular dairy number A32 recording 5.76 crore rupees in receipt, makes the assessment order erroneous as well as prejudicial to the revenue. And consistency in the assessment cannot be the ground to sustain erroneous order when vital material has been ignored. What are the cases referred? What are the cases discussed during this judgment? One is Malabar Industrial Company Limited. Second was CIT versus Bhaval Synthetics of Rajasthan High Court. And third one was of Rajasthan State Private Limited versus Principal Chief Commissioner of Income Tax Act. However, these three decisions are in the favor of the SSC, but this ITAT is against the SSC. What are the principal practical implications? I am not touching on that. I am not talking about the strength of the URL, but I will talk about the weakness of the judgment. This judgment definitely leads to more and more litigation, which is not the theme, which is not the vision of Indian government now. Because they are bringing a new bill which is talking about a reduction of litigation. If these kind of judgments are coming from ITAT, how we can expect a reduction in litigation? It will increase litigation, my dear friends. So friends, this is the potential weaknesses: increased litigation, taxpayer burden has been increased, and always there is uncertainty in the mind of the SSC, in the minds of the taxpayer, even if their assessment has been completed, the revisionary power should be there. And for that, it is my humble advice to all the Principal Chief Commissioner of Income Tax to act judiciously in not in the favor of revenue but in the favor of natural justice. Getting my point? So this is the key takeaway. I am not touching on that. What are the impact on human tax practice of this kind of judgment? You can read from the PPT, and this is our conclusion. This is the judgment given on the revisionary power by ITIT Nagpur. Now I am discussing another judgment again on section 263. Please with me, I am sharing another PPT with you. Just a minute. Now I am discussing another judgment given by ITT Mumbai, again from Maharashtra. Comprehensive legal judgment analysis on 263, same issue pronounced by ITT Mumbai judgment, but this judgment in the favor of SSC. Introduction to the judgment. The case involves Poorna Purushottam Export challenging a revision order passed by Principal Commissioner of Income Tax under Section 263 of Income Tax Act 1961. What are the legal contention? The legal contention, the primary dispute, the primary question, the primary argument centered around the jurisdictional validity of invoking Section 263 concerning valuation of closing stock and assessment discrepancies. The case highlights the importance of procedural fairness and limits the revisionary power in the tax assessment. What are the citation and case information? The case title is Poorna Purushottam Export versus Principal CIT, decided by Income Tax Appellate Tribunal Mumbai C Bench, and quorum. The judges for the same are Shri Narendra Kumar Chaudhary versus Shri Prabhas Shankar, and the judgment was pronounced very recently on February 18, 2025 against the appeal number 2143 of 2024. Friends, the ITAT Mumbai allowed the appeal, holding that the revision order passed under Section 263 was beyond the jurisdiction of the PCIT. Why beyond the jurisdiction of PCIT? We will also discuss on that. Adequate inquiry. The same issue we have discussed earlier. In the previous case, the AO failed to do the proper inquiry. AO failed in his duty. The AO has not performed his duty diligently in the decision given by the ITAT Nagpur. But in that particular case, the tribunal found that the assessing officer had conducted adequate inquiries and verification. Please note that the tribunal agreed on the fact that before making assessment, the assessing officer had conducted adequate inquiries and verification regarding stock valuation during the assessment proceeding. That's why evoking Section 263 was deemed inappropriate. As the assessment order was not erroneous and prejudicial to the interest of revenue. What are the issues, friend? The issue number one, whether the order passed under Section 263 was valid in light of condition precedent for its invocation. Second, whether the valuation discrepancies of rough diamond were properly considered in the assessment order. Whether the AO has conducted proper inquiry into the matter before finalizing the assessment. Arguments presented by the both parties. What appellant has contended. Assessment order was passed after due consideration of stock valuation. The appellant said during his argument that assessment order has been passed after due consideration of stock valuation. Principal Chief Commissioner of Income Tax wrongly assumed lack of proper inquiry and revised valuation included in the books of account and assessed accordingly. And what is the respondent? What are the department contentions? Assessment order erroneous and prejudicial to the revenue, failure to consider discrepancy in the stock valuation, inadequate examination of valuation methodology. What are the decision and judicial pronouncement by Mumbai C Bench ITAT. The AO has conducted, please note word by word, please note every word of this slide. The AO had conducted a detailed inquiry by calling for records, analyzing stock valuation, and questioning the discrepancies. And second thing, no prejudice to the revenue. No prejudice to the revenue. The Principal Chief Commissioner of Income Tax failed to demonstrate that the assessment order was erroneous or prejudicial to the revenue. And third very important thing, explanation 2 is inapplicable. Explanation 2 to Section 263 didn't apply as the AO had made adequate inquiries. Revision order set aside. That's why the tribunal set aside the revision order under Section 263. What are the legal issues settled? Both erroneous and prejudice to revenue must be certified. As said in the Malabar case judgment 25 years back by the Supreme Court, again considered by the ITAT Mumbai. Both the conditions are twin conditions and these conditions are to be satisfied, erroneous as well as prejudicial. Second, different view insufficient. A revision order cannot be passed merely because a different view can be possible. Due inquiry protection. Whenever you prove that the AO conducts due inquiries, whenever you prove that the AO conducts due inquiry, an assessment order cannot be set aside under Section 263. Assessment integrity. Assessment order must be passed on a substantial inquiry by the AO. Limited scope of Section 263. Burden on revenue. This is a practical ability, notable judicial observation. This is very important thing to be noted down. on recorded purchase. Please note that it is not the case of assessing officer. It is not the case of assessing officer that any of the purchases were not found to be recorded in the books of account. Second, a different view does not render an assessment order erroneous if due inquiries have been made. These are the cases again referred by the ITAT for deciding the that particular case. Again, Malabar Industrial Company Limited versus CIT, pronounced by the Honorable Supreme Court in 2000. That decision I am talking about. And second was CIT versus Gabriel India Limited 1993. Emphasize that mere lack of detailed discussion in the order does not make the assessment erroneous. Evaluation of judgment. What are the strengths, what are the weaknesses, and what can potential influence, and what are the final notes. So friends, it is all from my side for today's discussion. I have shared 2 PPTs with you. How you rate this session? Are you liking the same or not liking the same? Please tell me by writing in the chat box. Meanwhile, if you have any question in the
क्या
mind,
आप भी कानूनी जजमेंट्स को समझने में घंटों लगाते हैं? ये काम अब आसान हो सकता है। पेश है लेक्स जीपीटी, एक ऐसा एआई टूल जो आपको किसी भी कानूनी जजमेंट को सेकंड्स में डिकोड करके समझने में मदद करेगा। चाहे कोई भी कानून हो, कोई भी जजमेंट हो, लेक्स जीपीटी आपको देगा सटीक और तेज विश्लेषण। और खास बात, आपको मिलेगा फ्री स्टैंडर्डाइज्ड प्रॉम्प्ट जो आपके एनालिसिस को और भी बेहतर बनाएगा। अब समय बचाइए, काम कीजिए स्मार्ट और बढ़ाइए अपनी सफलता की संभावना। लेक्स जीपीटी किसी भी कानूनी जजमेंट को समझें तुरंत और आसानी से। अभी खरीदें और आजमाइए।
friends, please write in the comment section how was this session, what things you have learned, what more we can include in this judgment analysis session. Tomorrow we will come with another judgment on income tax. Through this platform, we will discuss that judgment also thoroughly and in detail once again with you. But your views, your suggestion, your valuable comments are precious to me. There is no value to that. Until or unless you tell me how was the session, what further can be included, what can be deleted from that, how the session can be made more fruitful, until you write in the comment box, I am not in position to understand this thing. If you don't want to write publicly, please drop down a mail at my mail ID bijgyan@gmail.com. I have mentioned my mail ID also. Anything you want to discuss, you can discuss, otherwise we will wind up the session. Yes, please. As I promised, every day we will bring at least one new judgment for you. I think no one want to ask anything, no one want to write anything. That's why we are winding up this thing. Thank you everyone for spending your precious and valuable time.